it's been settled. The province can't do things indirectly that it can't do directly. And neither can the municipalities, and neither can the federal government. They're also talking about the Ottawa River heritage and how, oh, you can't do this, you can't do that. Well, you want to know something? If it's not reserved in the letters patent, they have absolutely no say on your private property. And you all have riparian rights under common law. In 1999, there was a report done by a bunch of foreigners from Europe in regards to your water. This is fun. This report was done in one of the driest years we had in this province. And they used a sample of 47 farms to create a document for the entire province. Can you imagine? 47 farms tells them what everybody's farm across the entire province is going to be like. And these 47 farms were in not only the driest year, but the driest area of the province. And you want to know what the biggest questions that came out of that report were? What do the private property owners know about their common law riparian rights? You see, they knew that you didn't know your common law rights. And so then their recommendation was, well, because they don't know their rights, let's make legislation and take away those rights and give all the water to the Crown. That's in my Conservation Authority report. It's all in there. And Grand River Conservation Authority was quite happy to do this. All of them are. Except for the Crown doesn't own the water, because water is a species of land. And unless it's reserved in the letters patent, you own it. And that was proven in 2001 with Saker versus Middlesex. Saker had 8 acres. He wanted to use the Navigable Waterways Act and this stream going through his property to do a natural severance. He'd have 5 acres on one side, 3 acres on the other side. You know what the ruling was? The Beds of the Navigable Waterways Act wasn't applicable. He owned the river. Yeah, those patents, they don't mean anything. Not only that, I have the letters patent that enacted Trudeau's document. Did you know that? The 1982 document, and I refer to it as Trudeau's document. I will not in any way, shape, or form refer to it as part of our Constitution, because it is a communist document, and I prove it in my book. But it took letters patent, because did you know that there's actually 2 parts? There's a Schedule A and a Schedule B to that document. And in Schedule A, because we did not ratify the 1931 Westminster Act, Section 4, England could still make laws for Canada up until 1982. They could. But Section 2 of Schedule A of the 1982 document finally ratified Section 4 of the 1931 Westminster Act. I know lawyers that don't know that. I'm one of the very few people that ever dug that up. I had MPPs yelling at me saying, "You can't say that. We have the Westminster Act." And then I even had a lawyer actually put in writing that the last court case that ever went back to the Privy Council in England was in 1949, and yet I have a court case at home that went back in 1955. No one knows this, because no one's reading anything. This all started back in the 1950s, 60s. Actually, it started about 1946. But the big push started in 1974. And that's when they decided that the building code should be applicable to everybody and not just the municipalities and those developers who had entered into agreements with the municipalities. for the Ontario warranty, the home warranty, you know, that thing that's not worth its paper it's written on either? Yeah. You have a 1-year warranty for a brand new house. Guess how good that warranty is? Some people have been waiting for 6 years to get to court to get their money out of this warranty. Not only that, the new subdivisions, the majority of them are tear down now, because I know an engineer in the town of Collingwood who bought himself a brand new house in a brand new subdivision. And when he walked into his house, he took a look around and he walked out, and now he's suing the developer and the town of Collingwood because it's a tear down. That's how bad a shape it is. Building inspectors don't even know what the hell they're doing. Not all of them, some of them do, but not all of them. And they don't even know what the act really means. Municipalities are trying to pass tree cutting bylaws. They can pass tree cutting bylaws for their property or property that the private property owner has entered into an agreement, knowing and willingly, with the municipality. That's covered under Section 61, Section 135, Section 408, I think, Section 12 and 11 of the Forestry Act. It's also covered under Section 925 and Section 109 of the British North America Act. And if the trees are not reserved in the letters patent, there is no control whatsoever to create a tree cutting bylaw for private property in this province. And that's been proven 3 times now in the past year. Lambton County was going to be passing a tree cutting bylaw. The Lambton County landowners contacted me. I did a paper on tree cutting bylaws. One of the landowners read out that document at the council meeting in regards to tree cutting bylaws, and the warden said, well, our tree cutting bylaw would have been either immoral or completely illegal, and it will not be passed. Chatham-Kent, they're still undecided. The document is still at legals. And Dufferin County had a tree cutting bylaw in 2006, and they got our paper, and they have now repealed their tree cutting bylaw. Because now they know it's unconstitutional and it's unlawful for them to do that. But nobody is reading anything. The conservation authorities are pushing for everything. The conservation authorities are merely creatures of the municipalities, because the municipalities can actually dissolve and get rid of them under Section 13.1 of the Conservation Authorities Act. The conservation authorities are completely delusional with Section 28 because they think that they can regulate private property with the minister's consent under Section 28. There's one problem with that though. Under Section 21, they have to enter into agreements, they have to purchase, lease, or expropriate before they can implement any regulatory action whatsoever. And when they enter into those agreements are actually entered into under the Conservation Land Act. And the Conservation Land Act sets up the criteria for those agreements. That's in my report. This is the biggest problem we have in this province. Some municipalities are actually implementing, I'm glad you're sitting down. You have to get a permit to have a trailer or to camp or have a tent on your property. So if Johnny and the kids want to camp in the backyard, you have to get a permit from the municipality before your kids can do that. So I had to do a document up again on camping, tent, and trailer bylaws and explain to them that Section 150 through Section 164 is only applicable to public property. Like we all heard about the Havelock Jamboree, they can actually issue permits to people to come onto their municipal park to park their trailers there because the municipality owns that park. But they cannot tell you that you cannot have a tent or a trailer or camp in your own yard. They haven't figured that out. They tried every which way but loose to make sure. But the thing that they didn't understand was they were even trying to include that someone might be running around naked as a nuisance. Well, that's covered under the Criminal Code of Canada. So if they issued a permit for someone to do camping in their yard. They were actually saying, well, we're gonna flip the bird at the Criminal Code of Canada and you can run around naked if you want. But what they also are forgetting is, if they issue you permission to do anything, it's their insurance that has to cover you all. They don't know that, because they're the ones that are saying it's okay for you to do it. It's okay for you to commit a nuisance within your municipal boundaries. Yeah, they never thought of that. But 9 times out of 10, it's not even the councillors. Some of them are really bad. I look at the mayor of Ottawa. Yeah, no, you guys, you think you're laughing now because he's the mayor of Ottawa? Like, I'm just looking at him when he was the Minister of Municipal and Housing Affairs. Like, I just got to give my head a shake. So, the thing is, it's up to the municipal councillors now. Because actually, the municipalities can actually tell the province to go away. Yeah. You have that authority. But the municipal councils have to get a backbone. The province, through the Association of Municipalities, threatens our municipal councillors that they will not receive transfers if they don't do what the province tells them. So I thought the municipalities were supposed to be in charge of AMO. Why is AMO representing the province to the municipalities instead of the other way around? Not only that, the Association of Municipalities, they're doing little seminars now to tell you guys all how to be councillors, and that you guys have all this authority. Are you prepared for section 448.2 then, and the Criminal Code of Canada? Because last year in British Columbia, there's been an information put forward, an application in the courts, to have every councillor and 3 bylaw inspectors charged for breach of trust, failure to return property, and so on and so forth. I think there's like 6 criminal charges. And that had to do with issuing building permits and zoning. Our council